All right, welcome back to Daybreak. It's now 6:30 actually, and you're watching Daybreak, and I want us to take a look at some of the stories that are following up for you today, or what's happening in the country. And first, to begin with the situation that we know today is the final day for the BBI team. This is the implementation committee that was gazetted in January 2020. The term expires today, and what they expected to do is to file their report to the president, of course, advising on the implementation plan for the recommendations in the BBI report, and the proposals are to be made on how they think the review should be instituted in as far as constitutional matters are concerned, the laws, the policies, as well as administrative changes that are necessary. Also today, we know that the war on corruption continues. There are some two persons, one of them a former KRA official, expected in court. They're bearing in mind that they were arrested yesterday. That is Joseph Gikonyo and his wife by the name Lucy Kangai. They face charges of tax evasion, and the two are accused of failing to pay 38 million shillings in taxes through their company by the name Giche Limited, which they are directors. And Gikonyo and Lucy are also facing forfeiture of 597 million shillings in terms of property that they own that they could not explain. But also today, we know that the county revenue sharing formula, that is a new formula that is supposed to guide how resources will be shared amongst the 47 counties, how they're supposed to be done. So we know that the Senate will be meeting later in the afternoon to discuss that formula and agree on how that money should be shared. But of course, we know that some of the counties are going to lose in terms of the allocation because the previous formula has been favoring those counties that have higher levels of poverty index, and also those that have a larger land space in those areas. So those are some of the stories that are following for you. But also, I know you remember that today is the final day to file your returns with the Kenya Revenue Authority. So if you haven't done so, then I don't know what will happen to you. So you have until night time to do all that. So now let's focus on the story of the morning, that is the cost of corruption. And you know that last week there was that sentencing of two people, that is the Member of Parliament for Sirisia, John Waluke, as well as Grace Wakhungu. I don't know, they have the slides to take a look at what transpired in court last week in as far as what the decision by the Chief Magistrate there had to say. So we'll be looking at that later on, but as we prepare for that, let's speak to one of the defense lawyers, that is Dunstan Omari, who was representing John Waluke, the Member of Parliament for Sirisia constituency. And of course, we're still coming to terms with that sentencing. Of course, the conviction had been done earlier on in June, on June 22nd. How are you dealing with the decision of the court last week, Dunstan?
Thank you very much, and viewers. As defense team, our position is that we must appeal. We are in the process of filing our appeal. There are more than 3,700 handwritten proceedings. They are being typed. Once they are typed and we have all those proceedings, because we only have a typed judgment, we don't even have the sentence that it has not been typed, we are definitely moving to the High Court. We are determined to make sure that our clients are acquitted, because we believe that the magistrate did not address herself properly to the law and to the facts. Therefore, we'll appeal. And remember, we have 3 more layers to proceed.
Right. So you're saying that you're proceeding, but in the meantime, where is your client?
Our client is at prison. He's at industrial area, and therefore we are still in touch with him.
Right, and I remember that as soon as that decision was made on Thursday, we were hearing reports that there's some processing that was going to be done in compliance with COVID-19 regulations. Would you know what they are, so that we also understand what is happening to people that have been convicted and sentenced to some jail time?
The process is that once somebody has been convicted, they are retained at the police station until the medical protocols have been done, and our clients under those medical protocols, and therefore he is held up at industrial police station. That is a purely medical process in conjunction with the prison and the police departments of the Republic.
Right, and Dunstan, I remember hearing you in court, of course, during the mitigation hearing, and you quite made a case why your client and also the client of Duncan Okubasu, talking about Grace Wakhungu, why they should be treated in a lenient manner. Why are you satisfied with the judgment, and especially when it came to talking about what you thought should be the fine that they should be charged?
That's the reason why we are going to the High Court. The sentence was harsh. It was totally impossible to be met, because the reason why courts listen to mitigation is to make sure that they give an appropriate sentence. That sentence was harsh, leave alone that sentence, that conviction. We are challenging that conviction. Remember, Justice Mativo has put it very clearly that all citizens, senior citizens, should not be treated like me or you going to prison. So that sentence did not address the practical situation on the ground, and that is why we are going to appeal.
Right, and of course there was that question about, I remember for instance in Grace Wakhungu's case, the lawyer was arguing that the benefit was 40 million shillings, and I think the benefit for John Waluke was 50 million shillings. And so the argument was that the penalty should be double that amount and not double the 313 million shillings in the NCPB scandal. So what is the problem with the decision of the magistrate?
I wouldn't want us to litigate much about it here on the merits of that decision, because that's the decision that we are going to appeal. But the position we are saying is that the magistrate never addressed herself to the real law that after conviction, how the sentences should run. You've seen that those sentences are running for over 60-something years. We are challenging that, because what could be the better option for us? I wouldn't want to litigate much about our strategy. And remember, the DPP is watching. As we are discussing this, the prosecution is watching. We wouldn't want to give so much of our facts and our strategy. This is our war.
Okay, all right. Of course, I get your point, but let's only be speaking to one of the prosecutors in that case, that is Alex Mutete. But before we do so, let's take a look at some of the graphics that we have in as far as that would give us context of what transpired in court. If we can take a look at that, this decision that was reached on Thursday last week. Do you have the slides? Right, as we try to well, we'll try to bring you those slides shortly. But let's talk about the impact of such a decision on so many cases that are pending in court. I mean, what would be your view? Excuse me. What would be your view? Because this would appear like the first of firsts in as far as such a decision is concerned. Where then do we head in the war against corruption and also balancing the interest of the accused persons?
Our interest is to defend our clients. Our primary instructions is to be defense counsels. Mutete and the group, their concern is to prosecute and convict. We do not believe that the war on corruption will be exemplified or epitomized by the conviction of our clients. We came into this matter, me, Cliff Ombeta, Nyaberi, and Ondieki, at mitigation. We've taken up the matter full throttle, and we ensure that justice is done. The question about the war on corruption cannot be dealt with when convictions are based on political pigeonholes. If the way our client was treated, we do not believe that that was a proper application of the law. And therefore, if there is witch hunt, if the DPPs and government instruments are being used for witch hunt, then the war on corruption, if it is segmented in that line, it fails. But we believe that we will overturn those decisions in the High Court. Remember, the DPP has lost very many cases. We have blown the DPP and the state every other time. They also go to appeal. So this is not something strange. We are both to be forced. This is the part time the defense law, the technique and stride. We will overturn that decision as and when the High Court.
All right, let's take a look at some of those slides before we continue the conversation, just to understand what transpired in court or the impact of the decision. We have there that John Waluke, the Member of Parliament for Sirisia, of course, there was that charge that they defrauded NCPB up to 297 million shillings, and now the fine was 500,000. But on top of that, there was the mandatory fine of 594 million shillings, this being double the amount of 297 that he is supposed to pay. Also, Grace Wakhungu. Then Erad Company was fined 594 million shillings, being double the loss to NCPB, and now the fine for Erad Limited is also 500,000 under that charge, and Waluke is to pay half of that, and also for Erad Limited, he is to pay half of it. Then there's the question of defrauding NCPB, 13.3 million shillings. The fine is 500,000, but there's also a mandatory fine, which is double the amount. I believe this is according to the Anti-Corruption Crimes and Economic, Anti-Corruption and Economic Crimes Act, that Section 48, subsection 2, will talk about that mandatory fine being double the amount that could have been lost. Then there is Erad Limited charged, or rather fined, 26.7 million shillings, this being double the amount lost. And Erad Limited also fined 500,000 shillings. And now Waluke and Grace Wakhungu are to cost share that according to information from the DPP. Then on top of that, there is what they were accused of defrauding NCPB, $24,000 US. The fine, first of all, is 500,000. And also mandatory fine of double that amount, which is 48,000 US dollars. The same goes for Erad Limited, but that figure is to be shared between the two accused persons. And then also, as we conclude on this, so that becomes 7.6 million shillings. As we conclude on this, is that there's also other fines to do with so the personal benefit that he was accused of taking some 50 million shillings out of that deal, and therefore the fine there is double that amount, which is 100 million shillings. So now if you had to look at the total, Waluke is to pay 1.04 billion shillings or serve a prison sentence based on the different counts. I just want to hear from you, Dunstan Omari, from your understanding. So there are those people that have been calculating the figure to be 67 years in prison. How does this work based on what the chief magistrate decided on Thursday?
That's what we are saying, that that sentence was not appropriate, whichever the amount of time our clients are going to spend in prison. One, if somebody steals chicken, is he ordered to pay 2 chickens? Why do we have a disparity in terms of corruption matters? The man has paid, is told to pay fine and also double that fine. The principle of double jeopardy is not being adhered to. We intend to challenge the constitutionality of such sentences. Is there anything so special with offenses called ethics and corruption offenses? We do not think that every criminal must be treated. The Constitution provides in Article 50 and 49 the equality of every accused person. We can't have accused persons who have been charged under the Ethics Act treated differently. That is the basis of the discrimination we are seeing. We are seeing a lot of wars in the U.S. because of the discrimination based on racism. We do not want to have offenders or convicts treated differently. On the basis of that, we shall be moving equally to the Constitutional Court to declare those sections of the law unconstitutional.
But one wonders, Wakili, the arguments you make here, did you have a chance to make them in court before a conviction was passed?
I and the team have said me, Cliff, Nyaberi, and Undieki joined that litigation. The counsels who are handling this matter, we were not. That was the first time you saw us in court, and that is the speed that we move up. Either because we have not gotten the proceedings, we expected that our friends and our colleagues who are handling this matter must have raised those issues, and the court must have ignored those issues. If indeed those issues were raised and they are fundamental, they will be a game changer. If they were never raised, we will raise them up. Therefore, we expect that justice must be seen to be done not only to Waluke, but to every other Kenyan in this country.
All right, and Dunstan, just help us with your experience as a defense lawyer. We would wish to understand, because there are people who are asking, On Thursday, when they were hearing your team, of course, making arguments for mitigation, making an application to have court officers allowed to go and do some research on the background check of the accused person, specifically John Waluke, and to report back in some 5-6 days. One wonders, what is the place of mitigation hearing at a time that conviction has already been entered?
The purpose of mitigation, and this has been dealt with seriously in the Watetu case from the Supreme Court, it is very contextual. Mitigation puts the context of the person who is convicted and the sentence that he's going to get. There are other exterior reasons that one will get 10 years, another one will get 5 years, another one will get 2 years. The court did not agree with us, and that is a very serious issue. The court seems to have been made up her mind, that with or without a report, Kenyans are paying huge amounts of money for the Department of Probation to go and do reports of pre-sentence reports. They are provided by the law. The court did not allow that to come out. And the court dealt with that. Those facts that you presented before the court could have confirmed or found that we are not telling the court the truth. By failing to allow our mitigation to be taken into consideration, therefore, that is a serious ground for us to appeal. Two, you know very well that that judgment, that conviction was done at 8:10 at night. The Judicature Act does not allow courts to sit beyond 5. Was that sentence lawful? It is unlawful. It is an illegal sentence that was passed at the wee hours of the night. Those are some of the grounds that we are going to raise, that the court seems to be determined, regardless of the law, regardless of the rule of law, to pronounce itself. That it has pronounced itself. The lawyers say the court is now functions official. We will battle it at the High Court. The defense team never goes to sleep. Defense teams are always alert and will give the DPP a serious run for his money.
That's interesting. I find it pretty interesting that you should say that decision was illegal because it was made at night. But you are in court. I mean, you reported to court at 2 p.m. Of course, the appointment was in the afternoon, and allowed it to continue without any objection. The chief magistrate said she was going to write her ruling and deliver the judgment. I mean, deliver the sentence without objection. I mean, aren't you part of the decision?
Thank God Citizen TV was live. We did object. I personally, Danstan Omari, the defense team, informed the court that it is already 6. It's past 6. The defense led by Muteti also confirmed that the hours are not friendly. We did inform the court about the curfew and the issue. The court simply went ahead and ignored her plea. And remember, the final submission of our counsel Nyaberi was that let the court record the timing of the ruling, which was 8:05 or 8:07. So really, you've seen that either the courts have been intimidated to do what they are supposed to do, or they are not following the rule of law.
Okay.
That objection is on record. And Citizen TV, the clip that you play.
Okay, all right, and I wish you well at the High Court as you challenge this decision. So finally, how far are you in paying for the fines to secure the release of John Waluke?
We are yet to raise the money. It is quite a colossal amount of money. As I said, it was a sentence of slow death, raising all that huge amount of money. One, the law now is that the source of money must be verified. If anybody raises a million shillings, you must produce the source of money. The process is quite hard. Therefore, once we are able to raise the money, if ever we will raise the money, then we will pay. But if we will not raise the money, then that is why we are going to court to seek for at least bond pending appeal.
Okay, all right. Thank you so much, Danstan Omari, of course, who is the Member of Parliament for Sirisia in court. And of course, there's so many questions that we would raise in as far as his tenure as Member of Parliament is concerned. But all the same, those are issues that will be determined in the coming days. Thank you so much for your time. I see you laugh. I don't know why.
No, thank you very much. It's good you have wished us success. You are so excited.
Okay, all right. Thank you so much.